revealing the deeply restrictive nature of these arrangements and just how easily they can be abused and how difficult it can be to escape. Of course, I'm talking about Britney Spears. We know Britney Spears as an undeniable music superstar. She has been and will always be a cultural icon, but we can't forget she's also a mother. She's a human being. She's worthy of dignity and respect. For the last 13 years, she has lived under a conservatorship. That arrangement was initiated out of a concern for her mental health, but as has been reported and Ms. Spears herself has said, it appears to have been commandeered by those who were supposed to have her best interests in mind, but are now alleged to have effectively held her captive and profited handsomely at the expense. The allegations are, in fact, chilling. Ms. Spears was isolated, kept away from family, friends, and her broader support network. She was financially exploited. She was spied upon, including with a listening device in her own bedroom. She was medicated against her will, including being forced to be on birth control. She was even denied access to her own children. And yet, through it all, and in the public eye, she released 4 albums, headlined a $130 million global tour, and starred in her own Las Vegas show. So she was far from being incapacitated, as people ordinarily would know it. For years, we now know, Ms. Spears tried to end her conservatorship only to have her wishes ignored by the court. Sadly, we'll hear this afternoon that Britney Spears' story is not a singular or isolated incident. The only thing that's unusual about Britney Spears' story is that people are paying attention to it. That's the only thing that makes it different from many other conservatorships around the country. In fact, there are many others whose names, whose lives, whose stories we often don't know. They've experienced, and they continue to experience, this conservatorship trap. Under state laws, conservatorships are supposed to be a protection of last resort for those who are truly incapacitated. But we're learning, and many of us have seen in our own legal experience, that frequently they're imposed with little or no notice at hearings that last only minutes and have no consideration of other options. Many people under conservatorship arrangements aren't able to hire their own lawyer and instead are left to a court-appointed lawyer. Conservatees might not fully understand how restrictive these arrangements can be, and so they may not object before it happens. Many don't realize, or perhaps they're never made aware of the fact, that these conservatorships are difficult to change in any way, let alone end. And this issue is a big deal for a lot of people. In 2016, the National Center for State Courts estimated that across the United States, there were more than 1.3 million adults and at least $50 billion in assets under conservatorship. In my own state of Connecticut, there are about 20,000 conservatorships right now. There are about 4,000 new ones every year. These numbers likely only represent a snapshot, since most states don't have a centralized data collection system on conservatorships, and the data that they do collect varies from state to state. This afternoon, we're going to hear from witnesses who will tell us about their experience living with and fighting against conservatorships. They'll also tell us about how there are other options, better alternatives to these legal straitjackets. and they may be available to people who need that kind of extra support but can do without a conservatorship. One alternative that is gaining increased prominence is supported decision-making. I look forward to hearing from our witnesses about that alternative and others, particularly when they've had some success. Finally, let me just say Ms. Spears' next public hearing in her own conservatorship battle is literally tomorrow. While she continues to fight to make her own decisions and to live her own life, we can and we must fight for reforms in these legal straitjackets, arrangements that are potentially abusive and certainly a disservice to many people that are under them. And that's why I'm so pleased that the ranking member and I could come together to hold this hearing. I hope we can use this afternoon to have a productive discussion, find common ground, to identify ways to promote transparency, accountability, and overall reform of the current conservatorship system. And let me just pose a couple of initial thoughts to get your reactions to them. First, it's clear we need to strengthen the state systems to ensure alternatives to this kind of legal straitjacket and make sure they're considered first, make sure civil rights are protected, and where a conservatorship is imposed, that it is effectively overseen and supervised to avoid abuse. Second, federal agencies, including the Department of Health and Human Services and the Department of Justice, can promote the sharing of information and best practices across jurisdictional lines, as well as improve data collection. I know that our colleagues, Senator Casey and Warren, have begun considering that data issue. Third, we need to consider strengthening federal enforcement. The Department of Justice Civil Rights Division already has a disability rights section, but it has not historically focused on deprivation of rights and abuses in conservatorships. Maybe we need that kind of effective oversight and intervention. The scale and scope of abuses that we're seeing now demand a response. And those countless people who are victims of abuse because of conservatorships need protection. I look forward to hearing from you and working with my colleagues as we explore these alternatives. And I want to take a moment to extend a particular welcome today to Nick Klaus, who's here to testify about his own experience. We welcome you here. You're living as a subject of a conservatorship, and your fight to have your rights restored are an example of courage, and we welcome your, again, demonstrating that courage to share your story with us today. Thank you very much for being here, and I'll now turn to the ranking member, Senator Cruz.
Thank you, Mr. Chairman, and let me start by thanking you for holding this hearing. I think this is an important topic, and I welcome each of the witnesses for attending and testifying. Every so often, an individual case of injustice captures the nation's attention, and it opens our eyes to issues that are by no means unique to that individual, but that previously had remained hidden from the public. That's what has happened with Britney Spears, one of the most iconic American pop stars of all time, who has been under a California conservatorship since 2008. The case has captured the attention of the world, and I myself count myself emphatically in the Free Britney camp, and have been so vocally for some time. For more than a decade, someone else, Britney Spears' court-appointed conservator, has made all of the critical decisions in her life. Even though she's a grown woman who has grown to incredible heights in her career, even though she's a mother, to this day, She can't make basic decisions about her own life, her own career, her own health, or her own finances. Ms. Spears has fought this conservatorship, but it seems that at each critical juncture, the legal system has been designed not for her benefit, but to trample on her rights. When the conservatorship was first put into place, for example, Ms. Spears tried to hire a lawyer to fight the conservatorship. But the California court threw out her lawyer, saying effectively, no, she's not capable of hiring a lawyer. The court based its reasoning on a purported medical report. But because she didn't have a lawyer or a copy of the medical report, she didn't have someone on her side to challenge that determination. As a result, she was placed in a conservatorship, even though from outside appearances there was nothing to indicate the lack of competence that should have been required to justify a conservatorship for 1 week, much less for 13 years. Ms. Spears has made stunning allegations that because she is subject to the whims of the conservatorship, doctors force her to have an IUD, a birth control device, against her wishes because her conservator didn't want her to have children. That is not somebody else's choice to make. That is grotesque. This type of forced prevention of childbearing and forced sterilization, sadly it goes on all the time in oppressive nations and communist countries like China. And sadly it has an ugly, ugly history here in the United States. But few of us would have believed it was happening in America today. Given recent changes, including Ms. Spears' first ever public testimony in her conservatorship case, Brittany may be able to get out of the conservatorship as early as tomorrow, and if so, that will be a great victory for justice. But for so many people across the country, their conservatorships are likely to continue under the same system or a similar system as the one that has trampled on Ms. Spears' rights for over a decade. There are approximately 1.3 million adult conservatorship cases in the United States, with an estimated $50 billion in assets controlled by those conservatorships. And sadly, in at least some of the instances, it's all about the money and control of the assets in that conservatorship. Conservatorships can have their place. They can be necessary, they can be appropriate. They can help protect individuals who cannot care for themselves, whether because they suffer from a severe developmental or intellectual disability, or an injury, or an illness such as dementia. We rarely hear about conservatorships where honest and conscientious courts and conservators act in the best interest of the individual and are responsible and responsive to changing circumstances. Those cases don't make the news. Unfortunately, conservatorships can also be abused. They can deprive individuals of rights, of liberties, of opportunities to make decisions that most of us take for granted. We must be vigilant when individuals suffer from diminished capacity. We protect and we respect their personal liberty and their fundamental rights, including the right to make decisions that many of us disagree with or find irresponsible. And that's important here. The question is not whether you agree with every decision the individual might make. The question is whether they have such diminished capacity that the law has to step in and protect them. And that means ensuring that conservatorship process affords full due process protections, from basic steps like providing adequate notice of proceedings to ensuring that individuals have the right to counsel and that the burden of proof rests on the state. I talked a minute ago about the beginning of Britney Spears' case. For the court to throw out her lawyer based on a secret medical report that she couldn't access, the lawyer couldn't access, and couldn't be charged is something straight out of Kafka. It's not right. It's not how our legal system is meant to operate. Instead, we need to ensure that there is ample opportunity for people to contest conservatorships. We're fortunate today that one of our witnesses will be able to speak firsthand about how difficult it can be to terminate a conservatorship and to have his rights returned to him. It also means seriously considering alternatives to conservatorships and whether individuals have reasonable access to those alternatives. That could include supported decision-making, which allows an impacted individual to form a support network of people they know and trust and consult this group in the course of making their decisions. It could also include the use of representative payees, special needs trusts, joint bank accounts, power of attorney agreements, and advanced health care directives. As a general matter, state law and state courts create and manage conservatorships. That means that most meaningful reform should be driven primarily by the states, not the federal government. And the states are equipped to drive reform in this area. My home state of Texas, for example, has been at the forefront of reforming conservatorships to protect individual rights. In 2015, Texas was the first state to codify supported decision-making as an alternative to legal guardianship. Texas also implemented several other fundamental reforms, including a Bill of Rights for wards and increased court oversight of existing conservatorships. Other states, thankfully, have followed Texas's lead and have instituted similar reforms. The Britney Spears conservatorship has brought to light real issues with conservatorship law that should shock every American. If the conservatorship process can deprive someone like Ms. Spears, someone with immense celebrity, immense wealth, immense material success, of her fundamental liberties, then what chance does the average American have? Because of what has happened to Ms. Spears under California laws and California courts, states all across the country should be asking themselves what they can do in this area to make sure that they aren't falling into the same traps and that they are instead protecting the interests and the rights of every one of their citizens. I look forward to the discussion today. In today's polarized environment, there are many issues on which the two parties disagree. There are many issues on which Chairman Blumenthal and I disagree, and I'm sure we will again in the future, but I'm glad we have found a topic on which there is very significant common ground, and I know both of us look forward to learning more from our witnesses today. Thank you.
Thanks, Senator Cruz, and I will second the remark that he just made. Perhaps somewhat unusually, we are in complete agreement that this problem needs to be addressed, and we are also in agreement on the witnesses that we invited today, who are really impressive for all you've seen, all you've done, and so we welcome you. And before I introduce you for your testimony, I'd like to do a short video which will really demonstrate the fact that Mr. Klaus and Ms. Spears are among far too many people who have been impacted by unnecessary or abusive guardianships. We're going to have this video played now, if we may, and they're not sworn under oath, but we want to give you some idea. People from all over the country, literally, who couldn't be here and we couldn't have because of time constraints, but we'll give you a flavor of what their experience has been. We can do that video now.
When I was about 18, I got put in a full guardianship where they took all my rights away, the right to vote, the right to get married, the right to sue. Before I was in guardianship, I was able to go out with friends, go to the movies, go to the mall, volunteer, do a lot of volunteer work, and even go to the college. After I was put in the guardianship, I became fully restrictive, couldn't go see my friends, couldn't go see my family, couldn't go anywhere. I got my rights back back in 2016, where I was able to get all my freedom back with the supported decision-making agreement and be able to make my own decisions with people I trust.
I was in a group home. I did not want to be there. I told everyone that I was not happy and did not like it. I just wanted to live where I felt safe. I wasn't allowed to see my friends. I wasn't allowed to use my cell phone and my computer. I felt like a prisoner. But I didn't do anything wrong. It was like I didn't exist. Instead, I was kept away from my community, my church, and my friends. Just because people have a disability does not mean they need a guardianship. Many times, they may need just a little help.
I had a state guardian for almost a long time, but I didn't like it. I like to go places. When I had a guardianship, I felt like I was living in a prison. Now that I don't have a guardianship, I get released from prison.
Last fall, I had a court hearing to determine guardianship. I found out about it the day of the hearing. A few hours before the hearing, I told my parents that I did not want to lose all my rights. And there is this thing called supported decision making that would allow me to keep my rights and to get the help I needed to make the decisions on my own. They stopped the hearing. They got more information about supported decision making, and we decided to use it along with a power of attorney for finances and health. This allows me to keep my rights to make decisions.
The judge placed me under a professional guardian. During those past 9.5 years, my guardian would not allow me to have a cell phone, any kind of technology. She restricted me from my friends, my family, and she didn't even take in consideration of where I wanted to live. And she didn't even let me get my own clothes. I am so happy that I am off of guardianship so I could live my life.
I grew up in a state institution and I was released when I was 26 years old. I was required to have a guardian to get out of the institution. After living in the community for 3 years, I decided I didn't need a guardian. My guardian went to court with me, and the judge ended the guardianship. Now I have trusted friends in my community. I can turn to them if I need advice. I remain in control of my life.
My mom was trying to teach me how to be an adult by teaching me how to manage my money and what was important. The judge did not like me having a debit card to put gas in my car. She also did not understand why my mom was having me save money for tuition and car insurance. I wanted to go to school, but she said we spent my money on anything. I do not feel that the judge treated me like a human. She never talked to me. My doctor also felt I needed my rights back, but the judge would not listen to him either. I am now working full-time and going to college. I now manage my money and make decisions with just my parents' help. I would like to ask that you make guardianship the last option for others. They need to have a chance to make decisions on their own first. Guardianship took away everything from me. It needs to be the very last option.
Thanks to all who participated in that video, and thanks to our staff who recorded it. I'll now introduce the witnesses. Nick Klaus is 28 years old, and he is from Huntington, Indiana, where he lives with his wife, Chelsea, and their 4-year-old daughter. Ms. Klaus works full-time as a warehouse forklift operator. He previously worked as a welder and biotechnician. In a 2011 automobile accident just before his senior year of high school, Mr. Klaus experienced a traumatic brain injury that led to his parents obtaining a guardianship over his person and estate. Mr. Klaus began working to end the guardianship and restore his rights in 2017, and he was finally able to do so just last month, but only after he secured his own independent counsel with Indiana disability rights, and he engaged in lengthy legal proceedings. Mr. Klaus, welcome, and you can correct any parts of your story that I've gotten wrong so far when you testify. Zoe Brennan-Crone is a staff attorney at the ACLU Disability Rights Program. At the ACLU, she has advocated for conservatorship reform and the necessary protection of disabled people's civil rights and civil liberties. She's also worked extensively to help people with disabilities and use supported decision-making to expand public understanding of the risks and civil liberties harms of guardianship and the potential of alternatives. Ms. Brennan-Crone has represented and advised people seeking to get out of guardianships. She's drafted and argued an amicus brief in Britney Spears' conservatorship case, and she's joined more than 20 disability and civil rights organizations. That brief has been joined by that many. And she's highlighted the disability rights and constitutional aspects of the Spears case and urged the court to allow Ms. Spears to select a lawyer of her own choice, which she now has been able to do. Morgan Whitlatch. Morgan Whitlatch is the legal director of Quality Trust for Individuals with Disabilities. She also serves as the lead project director of the National Resource Center for Supported Decision-Making. Ms. Whitlatch has devoted her legal career to working with and on behalf of people with disabilities and older adults in matters involving capacity and guardianship alternatives. Ms. Whitlatch's extensive experience also includes co-representing an adult with Down syndrome in fighting for her right to engage in supported decision-making, as well as representing the first senior in DC to have her guardianship terminated in favor of supported decision-making. Dr. Clarissa Kripke is a clinical professor of family and community medicine at the University of California, San Francisco School of Medicine. She has a comprehensive background in primary care of transition-age youth and adults with developmental disability. She directs the Office of Developmental Primary Care, a program dedicated to improving outcomes for people with developmental disabilities across the lifespan, with an emphasis on adolescents and adults. David Slayton. He is the Vice President of Court Consulting Services at the National Center for State Courts. Mr. Slayton is a former state court administrator for Texas, as well as the past president of the National Association for Court Management. Mr. Slayton has been employed by the judicial branch in various roles since 1998. He has previously provided testimony to the Senate Special Committee on Aging regarding the exploitation of older Americans by guardians in Texas. He's helped lead guardianship reform efforts in Texas, including supported decision-making, and he's an advocate for increased regulation of guardians by the state. If you would all now rise, I will administer the oath. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Mr. Klaus, we'll begin with you.
Thank you for having me. Good afternoon. My name is Klaus, and I want to thank Senator Blumenthal and Senator Cruz for the invitation for having me. In July of 2011, I was in a terrible car accident that left me with a traumatic brain injury, headaches, and memory loss. Thinking that someone might take advantage of me if I were to receive a large sum of money from a personal injury lawsuit, my parents convinced me they should become my legal guardians. They told me to sign a piece of paper and that would let them take care of the lawsuit so I could focus on recovery. There was no discussion about what this would mean or what rights would be taken away from me or whether something less restrictive might have met my needs at the time. I do not know whether a hearing was even held before a judge signed the order that essentially turned me back into a child in the eyes of the law. In September of 2014, I was blessed to meet my now wife, Chelsea, and the mother of my child. The symptoms from the TBI that had improved by that point, but my vision of the future was clouded by constantly being told that I could not do what I could not do. But when Chelsea looked at me, she saw who I could become. On Valentine's Day 2016, I asked Chelsea to marry me. I was excited to start a family, but my parents were extremely hesitant to allow me to work, let me get married. 2 months later, we found out Chelsea was pregnant. This was unquestionably the best thing that had ever happened to me. And I'm not sure my parents would have ever allowed me to get a job or move out if that hadn't happened. With a baby on the way by that summer, I had moved into Chelsea's house, which we still live in now. I worked full-time as a biotechnician at a nearby ethanol production facility. In December 2016, I became a father, but in many ways, my parents still treated me like a child. I had no control over my paychecks. I earned and had to get permission from my stepfather to buy diapers and formula for my daughter. My parents wholly controlled my earnings and refused to even provide the contact information for the trustee overseeing my settlement funds. I could make medical appointments for my daughter, but I was not allowed to make them for myself. My parents finally allowed Chelsea and I to get married in May of 2018. Before and after the wedding, I regularly asked my parents about ending the guardianship. They eventually arranged a meeting between their lawyer and my wife and I, or my soon-to-be wife and I, and basically told us that the guardianship was unable to go away, and they had the power to fight us if we ever contested it. When we heard about Indiana Disability Right, our state's protection and advocacy organization, and reached out to them in spring of 2020, I did not know what to expect without having any control over my finances. I had no way to hire my own attorney. If the IDR had not accepted my case and offered to represent me free of charge, I'm not sure if I ever would have had a path out. When the petition to terminate guardianship was filed January of 2021, my parents refused to even consider agreeing to it until I first underwent a psychological evaluation. When the evaluation was finally released, the psychologist chosen by my parents determined that I had no need for legal guardianship. Sorry, I'm out of time. Do you want me to finish, or?
You can take a couple minutes more.
Thank you. After everything I've been through, I'm incredibly lucky to be in my current position. I have a wife who's my best friend and biggest supporter, and a healthy child who is the light of my life, close friends and family, and a successful career. If it was this difficult for me to be released from unnecessary guardianship, I cannot imagine what it is like for those who are not as privileged. We need better protections to keep this from happening, and we need more attorneys like Justin and the Indiana Disability Rights to enforce those protections. Thank you again, Senator Blumenthal and Senator Cruz and the rest of the subcommittee for having me.
Thank you. Thank you for that excellent testimony. I understand your wife may be with you today. You can acknowledge her if you wish. Thank you. We're going to go now to Ms. Brennan-Cohn.
Thank you. It's a tough act to follow. Chair Blumenthal, Ranking Member Cruz, thank you for inviting me to speak today and for convening this hearing. My name is Zoe Brennan-Crone, and I'm a staff attorney at the ACLU Disability Rights Program. Britney Spears' high-profile case battle to get out of conservatorship was the first time many people in this country had heard of conservatorship or guardianship, and I'll use those terms interchangeably. But guardianship is, as we've heard, a widespread phenomenon. It's estimated that courts have stripped 1.3 million people of their civil liberties. The most unusual thing about Britney's case is the attention it's getting. Spears' experience of getting into a guardianship in a period of crisis, then facing a Kafkaesque maze to try to get out, is astonishingly routine. Guardianship is fundamentally a civil liberties issue. It is the government stripping away a person's civil liberties and autonomy. It has been called a civil death. If you are under guardianship, you cannot decide where you will live, who you will spend time with, who you won't spend time with, how you will earn and spend your money, or what medical care you will get. And guardianship is fundamentally a disability civil liberties issue, because only people with disabilities, or perceived to have disabilities, risk this type of civil death. People with intellectual and developmental disabilities, psychiatric disabilities, and older adults who age into disabilities like dementia are at particularly high risk for guardianship. Guardianship is a major invasion by the government into a person's life. It's dangerous to be in a guardianship. The enormous power of the guardian, coupled with the lack of transparency and oversight, is a recipe for abuse, neglect, exploitation, and harm. I want to be clear that many individuals involved in guardianships are acting with the utmost good faith and integrity, but systemically, guardianship is dangerous. Yet the harms and risks of guardianship stand in alarming contrast with the routine approach that courts take in establishing them. Guardianships are often established as a matter of course, with few of the due process protections that should accompany such an invasive loss of rights. Notice, opportunity to be heard, access to counsel, and mechanisms to end a guardianship are often entirely absent or, at best, inadequate and inaccessible. Many people have lost their civil liberties without having any idea of the gravity or permanence of guardianship. We need to change this system. We need to strengthen due process protections and treat guardianship like the invasive last resort that it is. And we need to make changes beyond guardianship, towards a world in which far fewer people are in guardianship and far more people with disabilities live self-directed, autonomous lives with the supports they need and want to do so. Part of this requires changing our conception of independence and recognizing that none of us live truly independent lives. We are all interdependent. We all rely on others, friends, lawyers, staffers, reminder apps on our phones, to live our lives. People with disabilities use these same types of supports. Some people have more significant support needs, but they also have preferences and wishes and values. We need to strengthen and encourage structures in our society through which people with disabilities, like those without disabilities, can get the supports they need and want to live their lives consistent with their own preferences, all while retaining their core civil liberties. Supported decision-making is a key model for this, and my colleague Morgan Whitlock Morgan Whitlatch will give you more information on this. While guardianships are primarily established by state law, Congress can and should change this system. First, Congress should set up guardrails to strengthen the due process protections within guardianship. It should recognize and remedy the constitutional violations that pervade guardianship proceedings. This includes identifying and enforcing minimum due process rights, including a right to accessible notice, a right to counsel, meaningful participation in a hearing, and meaningful access to counsel and support to dissolve existing guardianships. Because guardianships have existed in the shadows for so long, Congress should also fund data collection so that we know who is under a guardianship, public education on the risks of guardianship, and monitoring of state court systems to reduce their use of guardianship. But Congress should also take steps to strengthen the world of voluntary support and self-direction outside of guardianship. Congress can and should recognize and advocate for alternatives like supported decision-making, which allow people with disabilities to get the supports they need without government intervention or losing their civil liberties. Congress should encourage the Department of Justice and other agencies to formally identify supported decision-making as a reasonable modification and a less restrictive alternative that must be tried before guardianship. Thank you, Senators, for your interest in this issue and for holding this hearing, and I look forward to your questions.
Thank you very much. Now, Morgan Whitlatch.
Hi, Senator Klaus, Senator Cruz, and members of the subcommittee. Thank you so much for
I think you may have to turn on your microphone.
I did. Okay,
There
thank
you
you. Thank you for that. Thank you for the invitation. My name is Morgan Whitlatch, and I'm the Legal Director of Quality Trust for Individuals with Disabilities. Quality Trust is an independent advocacy and monitoring organization based in Washington, D.C. We also lead the National Resource Center for Supported Decision-Making, which was created in 2014 and is dedicated to advancing the decision-making rights of people with disabilities and older adults through training, technical assistance, research, and promotion of promising practices. Through Quality Trust Jenny Hatch Justice Project, we provide legal advocacy and representation to assist people with disabilities, including older adults, to access less restrictive options for decision-making support and to go to court to prevent, limit, or end overly restrictive guardianship. We served under cooperative agreements with the National Council on Disability that resulted in 2 reports analyzing the impact of guardianship and alternatives through the lens of the U.S. Constitution and federal civil rights laws and policies. Those NCD reports offer findings and recommendations to the administration and Congress that can inform this subcommittee's deliberations. We also were involved with the 4th National Guardianship Summit that resulted in recommendations in the May of this year. Britney Spears' story has shined a national and very public spotlight on the problems of guardianship and conservatorship systems. In our almost 2 decades of working with and on behalf of many people impacted by these systems, Quality Trust knows that Ms. Spears is not alone. We have seen the kinds of rights restrictions she reported experiencing imposed upon adults of all ages, with different diagnoses or disabilities, life experiences, and socioeconomic backgrounds. And we know through direct experience how hard it can be to get a guardianship eliminated or terminated. Today, so far, you've heard directly from Nicholas Klaus from Indiana and those wonderful videos that you showed. But there's so many more stories from people around the country, and it's those testimonials that are the most important and the most compelling reason why reform must happen now. My colleague Zoe Brennan-Cohen rightfully emphasized the need for federally supported reform to address serious due process problems within guardianship and conservatorship systems. In my almost 20 years of legal practice, I have seen such problems firsthand, over and over and over again, and they pose significant and untenable challenges to people facing guardianship petitions and those seeking redress from the court or having those rights restored. We welcome federal scrutiny of guardianship and conservatorship systems, and we thank this subcommittee for its leadership in this conversation. In responding to this strong public outcry for change, we urge you not to concentrate reform solely on efforts to make guardianship and conservatorship systems better or improved. More attention and investment must also be placed on reforms that promote the avoidance of guardianship and conservatorship in the first place, as they are overutilized legal tools that have the effect of removing legal personhood from an individual. This means taking concrete and decisive steps to dismantle the many pipelines to overbroad and undue guardianship, including those linked to schools, healthcare providers, adult protective services, and the legal profession, among others. It means promoting less restrictive and voluntary options such as supported decision-making that advances self-determination and does not involve the courts. Supported decision-making occurs when people use their family, friends, and others they trust to help them understand the choices they face so that they can make their own decisions. It allows a person to retain their legal rights while getting support from those they choose and trust. SDM is already part of the mainstream disability rights discourse, and it's gaining traction for older adults as well. It's been the subject of pilots, state legislation and laws, and court decisions terminating or refusing to order guardianship. It also has been recognized and endorsed by influential associations, national organizations, and federal agencies. But more work is needed to ensure that its promise and practice actually reaches more people with disabilities and older adults across the country. Promotion, expansion, and advancement of supported decision-making should be considered one of the ways in which to address the problems identified here today. My written testimony includes additional recommendations, but I'll focus my limited time on some key ones. In addition to the ones Ms. Brennan Cohen referenced, Congress should urge the Department of Justice to issue guidance recognizing and clarifying that supported decision-making is a reasonable modification that public entities and accommodations must recognize in order to avoid disability discrimination under the Americans with Disabilities Act. Congress should ensure that already federally funded programs, such as those associated with the Individual and Disability Education Act, are not pipelines to overbroad and undue guardianship by funding technical assistance and demonstration projects on using alternatives to guardianship and promoting training. Congress should support programs that fund grants to promote states adopting and implementing supported decision-making. Congress should support qualified legal service programs, independent from the courts and steeped in civil rights advocacy experience, to provide legal assistance to individuals like Nick, who are trying to avoid guardianship or have their rights restored. And Congress should also fund incentives to support the state collection of data that Zoe spoke of. We also would encourage the continued funding of the National Resource Center for Supported Decision-Making to coordinate national practices. Thank you, Senators, for your interest in this issue, and I look forward to answering your questions.
Thank you so much, Dr. Kripke.
Senator Blumenthal and Senator Cruz and members of the subcommittee, it's a great honor to be here to talk to you about conservatorships. People with disabilities have the same freedom to pursue their dreams as other Americans. My name is Dr. Clarissa Kripke, and I'm the Director of Developmental Primary Care in the Department of Family and Community Medicine at the University of California, San Francisco. I provide primary medical care to some of the Bay Area's most medically fragile and behaviorally complex residents. I'm the Vice Chair of Communication First, a national nonprofit that is focused on the rights and interests of people who cannot speak or whose speech is unreliable for communication. I also have personal experience as a parent. My daughter cannot speak and requires help with all of her activities of daily living, but she can direct her life and her health care. One of the most common reasons that people cite for pursuing conservatorships is that they fear that their loved one won't be able to access medical care or that family members won't be able to provide support. In my experience, number one, conservatorship is not necessary to deliver high-quality medical care. This is true even for people with the most complex disabilities. Two, conservatorships don't make people safer or prevent abuse. In fact, people with disabilities, as well as conservators, can get trapped in bad situations. Three, supported decision-making simply works better than conservatorship. Conservatorships encourage healthcare providers to focus on who is authorized to make a medical decision instead of on the patient. In one case I had, a patient came to me with her sister who thought something was wrong but didn't know what. I suggested that we try to ask. I put her in front of a keyboard to see if she would type. I asked her to show me how she says yes. I showed her some anatomy charts to see if she would point. Finally, I said, "Touch hurt," and she took my hand and put it on her right upper abdomen And based on that, I got an ultrasound and I was able to diagnose gallstones. That would have been a very difficult diagnosis to make if I had assumed she had nothing to say. Conservatorships don't protect people with disabilities from abuse. Choice and control over one's life is what makes someone safe. Most conservators are trying to do right by someone they care about. However, statistics show that most abusers are family members, caregivers, or other trusted people who a judge might appoint as a conservator. I had a patient who we suspected was being abused by their conservator. Because of the conservator's privileged role, Adult Protective Services closed the case quickly due to the lack of proof. Had my patient not been conserved, her distress and our suspicion would have been enough to help her end visits with the conservator and to help her choose someone else to provide her support. Conservators can also get trapped in a role they no longer can fulfill as they age or their circumstances change. I've had to try to contact conservators who reside in nursing homes or out of the country, who are only available during business hours, or who are actively avoiding being called. Delays in making medical decisions can be life-threatening. Supported decision-making simply works better. Supported decision-making is a process where people with disabilities can name trusted supporters to assist them with communicating, accessing health services, and making decisions and implementing their health care plan. It improves communication. It's flexible and respectful. Instead of relying on a single person, it enables a person with disabilities to receive support from family members or supporters whose knowledge, skills, and availability are best matched to the situation. Despite our best efforts, there are times when we can't clearly determine a patient's preference. In those situations, we invite the people in the patient's life to help make decisions as a team. At the meeting, we address the patient directly, regardless of whether we think they're understanding and even if they aren't responding. Patients often surprise us with their understanding and their insight. Also, the healthcare team behaves more respectfully when speaking directly to a patient. Overall, for the delivery of healthcare, involving courts doesn't add value. It doesn't prevent abuse. Supported healthcare decision-making gives people with disabilities control and flexibility they need to make medical decisions in a timely fashion so they can get the best care. Thank you, and I'm happy to answer any questions.
Thank you. Mr. Slayton.
Chairman Blumenthal, Ranking Member Cruz, and distinguished members of the subcommittee. My name is David Slayton, and I'm the Vice President of Court Consulting Services at the National Center for State Courts and former State Court Administrator for the courts in Texas. Conservatorship, or guardianship as it's called in Texas, is a proceeding in which a court, after determination by a judge that an individual lacks mental capacity to make decisions independently, appoints a guardian to make decisions and oversee the affairs of the individual. It is the most restrictive form of oversight a court can place on an individual outside of the criminal context, sometimes referred to as a civil death penalty. Guardianship is meant to protect individuals from abuse or exploitation by others due to the limitation in their mental capacity. In most guardianships, this is exactly what happens. Family members or friends protect their loved ones with intense attention to the needs of the individual. But sometimes this doesn't happen. Sometimes the individual is placed in a restricted facility and rarely visited. Sometimes the individual regains mental capacity but remains subject to the guardianship for years. Sometimes the trusted guardian begins to pilfer the individual's hard-earned estate, and sometimes the individual dies under the guardianship, but the court is not made aware of that for years. This isn't supposed to happen. Courts are charged with closely scrutinizing guardianship proceedings, beginning at the point where guardianship is sought and lasting throughout the guardianship. The courts do this by requiring certain information prior to establishing guardianships, regular reports from the guardian about the well-being of the individual, and detailed accounting reports about the revenue and expenditures from the estate. Without adequate resources or staff, judges are asked to serve in the role of judge, social worker, law enforcement, and accountant. In a review of over 55,000 cases in Texas, the judiciary found over 5,000 individuals who were deceased without the guardian alerting the judge. 40% of those cases lacked current required reports, meaning that the court was uninformed about the well-being of the individual or how the guardian was managing the finances of the estate. The Texas Judiciary has been working diligently to address these issues by providing resources to courts and making statutory changes. Some of those include requiring attorneys and judges in guardianship cases to explore all alternatives to guardianship prior to establishing one, to consider the ability of the individual to make his or her own decisions about residence, to provide for a regular review of the necessity of continuing the guardianship, and to create a new alternative guardianship called supported decision-making, the first state in the country to do so statutorily. Texas also enacted a robust Bill of Rights for individuals under guardianship. After finding that 98% of all issues were in guardianships where family members or friends were the guardian, Texas now requires family members and friends to register as guardians with the state, have a criminal background check, and participate in online training about their responsibilities as guardians prior to their appointment. Texas has also appropriated $2.5 million and provided 28 new employees to assist judges statewide in monitoring guardianships and reviewing annual accountings for financial fraud or exploitation. And lastly, just this year, Texas continued its reforms by providing this additional authority to have specialized guardianship courts and increasing the ability to access financial records from financial institutions. Texas is not alone in its desire to improve monitoring of guardianship cases. The Conference of Chief Justices and Conference of State Court Administrators have worked collectively to make improvements in this area for over a decade, making recommendations for reform and endorsing at least 14 resolutions in the past 10 years. Unfortunately, most state courts lack the resources to put these kinds of reforms into action. While states and state courts are responsible for the oversight of the guardianship system, there are several areas where the federal government could assist. First, Social Security representative payees are not always the same person as a court-appointed guardian, meaning that the state court is responsible for monitoring the activities of one person who may be managing a portion of the individual's estate or well-being, while another not under the state court's control is managing some other portion of the individual's finances, even when the state court removes a bad actor for cause. SSA does not honor state court orders and limits the exchange of information between the state courts and Social Security Administration. Second, bad actors who run into issues establishing a guardianship in one state may choose to move the individual and seek a guardianship in another state. Or an individual found by one state court to have abused or exploited an individual in one state may move his practice to another state, only to be court-appointed again without knowledge of the issues of any other state. Giving congressional consent to a interstate compact creating a national registry of guardianships and procedures is critically important. Lastly, the federal government could assist the state courts by enacting an adult guardianship court improvement program to provide targeted funding to each state's highest court, similar to the extremely successful Child Welfare Court Improvement Program, to improve data collection and analysis, evaluation, development of best practices and training, and collaboration to improve the management and outcome of guardianships. I look forward to answering any questions from the members of the committee. Thank you very much.
Thanks so much to all of you. We're going to begin a first round of questioning. A vote has been called, so I'm going to begin with a round of questioning. I'm going to go vote while Senator Cruz then asks a round of questioning. If he finishes and I'm not back, we'll take a short recess and I'll be back to follow up with more questions because your testimony has really raised a series of very profound and important issues that we should discuss and make a record of. I will just tell you a lot is going on in the United States Senate today and this week. So I apologize that some of my colleagues are not here. They may appear, but there are all kinds of meetings and floor proceedings going on, but have no doubt that what you say will be read. It will be not only part of the record, but I'm hoping that it will give rise to action in the form of proposed legislation and that it will be bipartisan because we have that kind of consensus here on the need for some action. Let me begin with you, Mr. Klaus, if I may. You have worked consistently since your injury, pretty much consistently, as a warehouse and forklift operator, a welder, a biotechnician. You've clearly been productive, and you also have some income as a result of the personal injury case that was brought on your behalf. Let me ask you if you could expand a little bit more on how the guardianship affected your financial decisions or your inability to make decisions even after you were married. You made reference earlier to the guardian or conservator having to approve your purchases of diapers and baby formula. Maybe if you could expand on the impact on your financial decisions of the guardian or conservator.
Yeah, it went as far down to is asking. I had to ask for money every time I wanted to make a purchase, and it could be all the way down to just wanting some gas so I could get to work. And I'd say more times than not, any of my requests, they'd be denied.
So those requests actually were denied when you asked to spend money?
Yes, and my wife, well, it's just my fiance at the time, and then after she became my wife, she had to pick up those costs.
So she was paying for your expenses because the conservator or guardian was denying
Yes.
permission. And how did that make you feel?
Worthless, to be honest.
I can understand.
Absolutely worthless. Work all those hours and not be able to bring that money home to my family.
So you were earning that money, but you were denied the right to decide how to use it.
Yes.
Ms. Brennan-Cohn, that is pretty striking for me, and I wonder if I could ask you whether that happens a lot, whether it's common. I'm struck by the fact that those paychecks from Mr. Klaus's job paid the legal fees, among other things, for the parent's lawyer. And that strikes me as a pretty stark conflict of interest among many other indignities that it caused Mr. Klaus. Maybe you could talk a little bit about that facet.
Certainly. We don't have, as many people have said, we don't have comprehensive data on anything in this sphere. We don't even know how many people are in guardianship, so we don't know statistically how often this happens. But a guardian or a conservator having control over the person's money is a very routine part of guardianships and conservatorships, and how that control is exercised is very much in the hands of the guardian, who can make choices out of spite, who can make choices because they think the person should be prioritizing other things, they think they're going to the gas station, whether the gas is more expensive, it can be anything. And so these types of experiences where people are sort of, it's really creating dependence where it's not necessary, and that has a real harm on people financially, but also emotionally as well. The way Nick has testified to how this affected him is very compelling, and unfortunately is not an unusual situation.
That one word, worthless, is haunting.
Yes, and the idea of guardianship is supposed to be this sort of benevolent way to help people, and it is so far from that in so many cases. In cases where there's outright abuse, and even in cases where there isn't. The message that you're being told that you're a child and your choices and your wishes don't matter is an extraordinarily compelling message to give people, and very, very harmful.
But in some ways, it's worse than treating someone as a child, because a parent, I'm a parent of 4 children, tries to really develop decision-making and encourages someone to make a decision, even though you may think as a parent, it's not the best thing in the world to do. The idea of decision-making is that you learn from mistakes. That's sometimes how we learn best. At least I'm speaking for myself. I made a lot of mistakes.
Yeah, exactly. You're exactly right. It's treating capacity and what you can do as completely static, that what you can do right now is all you'll ever be able to do, which is particularly devastating for people who get into guardianships right when they turn 18, people with intellectual and developmental disabilities. It's called the school to guardianship pipeline. And to be told when you're 18, I think many of us can think back of when we were 18, and if a judge looked at, how things were going, they might have had some questions, right? And we sort of learned from those, and things improved. We hope for many of us in some ways. And that is presumed to be not what's going to happen for people with disabilities. And that's simply not true. People with disabilities learn, they might learn differently, but they learn, and you're told that if you can't count back from 100 by sevens, you can't do anything in your life. Like, unless your job is counting back from 100 by sevens, that is not a core life skill.
I have a lot of other questions. I'm going to pursue them. I'm going to turn to Senator Cruz. He has another commitment, I believe, a floor speech at 4 p.m., so I'm going to let him do his questions. I'm going to vote. I'll be right back.
Thank you, Mr. Chairman. And I will say, Ms. Brennan Crone, I very much hope that senators are not expected to count backwards from 100 by sevens. I was told there'd be no math in this hearing, Mr. Chairman, and I'm really concerned that you've changed the rules on us.
I share that hope.
And the Senate would be a much smaller body if that were a test required for continued membership in it. Thank you to each of you for your participation in this hearing. Thank you for addressing these important questions. As I listen to these policy issues, I'm reminded of 22 years ago, in 1999, I was a young policy staffer on the George W. Bush campaign when he ran for president. And it's where I met my wife, Heidi, and one of the policy responsibilities I had was focusing on disability issues. And I worked with then Governor Bush. I worked with a number of disability rights advocates in designing what became one of President Bush's first initiatives, the New Freedom Initiative, which we hammered out on a laptop with bullet points, and it ultimately got enacted into law. And the guiding principle was that individuals with disability, like everybody else, want to be free, want the maximum autonomy possible, want the maximum independence possible. Not every person is capable of total autonomy depending on their circumstances and their physical condition. But to the extent possible, everyone deserves to have the right to control their own life, whether we agree or disagree with the decisions that person might make. And I think this discussion, all of the witnesses powerfully highlighted that. I'd like to start my questioning, Mr. Klaus, with you. I want to thank you for being here. This can be a daunting place, and telling your story, I'm sure, is not easy. But I want to thank you for your courage, because right now there are people at home watching this on television who may, like you, have faced a traumatic brain injury or some other accident where they're struggling with the repercussions of it. And there may be people in conservatorships who themselves are wanting to be free of those constraints. And your courage, I believe, is inspiring people at home right now. And so I appreciate that. I have to say, sitting and listening to you and hearing your story, you're a grown man. You're gainfully employed. You've had a series of impressive and difficult jobs. You're a husband, you're a father, and yet you lacked, for a significant period of time, the legal right to make decisions in your own life. And I think for a lot of people, that's an astonishing state of affairs. Could you share with this committee, while you were under the guardianship, what kind of decisions and activities were you not allowed to make on your own? And how has life been different after it was terminated?
Well, first off, I talked about my I wasn't allowed to make financial decisions or medical decisions. I wasn't allowed to decide who I was allowed to hang out with or where I was allowed to go. I was pretty much treated as a child in every aspect, even down to what phone plan I could be on if I wanted to, if I had a phone. But since then, it's life-changing. First thing I did was I was able to go fill up my tank of gas and not have to worry about my card getting declined even before swiping it. And I haven't done anything irresponsible or anything since I had the guardianship terminated, but I'm just living like a normal adult, and I'm finally watching my hard-earned paychecks come in, and it actually feels amazing. I lost that sense of worthlessness when August 24th hit.
Well, thank you for sharing that. As someone who Heidi and I just celebrated our 20th anniversary, and I will say, if what you said is right, that you haven't done anything irresponsible, you may be the only husband on planet Earth who can make that claim. I certainly would not be so bold as to say such a thing. Ms. Whitlock, we've heard about the constraints that Mr. Klaus faced. We have also heard about the constraints that Britney Spears is facing. In your experience, how unusual are these constraints for people facing conservatorships, and how does Mr. Klaus's story or Britney Spears' story compare with the other clients you work with?
I wish I could say they're uncommon stories. They're not uncommon stories. I've been practicing in this area for around 20 years, and I've seen many people in the same kind of situations, having their health controlled or psychological, not having control over their psychiatric treatment, not having control over their money, not having access to a cell phone, not even their own ID, not even being able to travel. All of these other kinds of issues are very common, and they affect people with all kinds of disabilities, all ages. And so I wish I could say that these were outliers in some way, but they're not. Unfortunately, guardianship can be very restrictive, and there's not the same kind of court oversight that people think there's going to be in a guardianship. Like, you think you go to court, you think you're going to have a court that's going to be overseeing this. It's very uneven kind of court oversight. And so unfortunately, I hear a lot of stories like this.
Thank you. Ms. Brennan Ms. Whitlatch just talked about the lack of court oversight. You also talked about the lack of due process protections. In your judgment, what due process protections are lacking, and how can they be improved?
In a lot of cases, they're almost all lacking. There's really, the whole way down the line, guardianships are launched and implemented and imposed as though they're very routine, sort of pro forma circumstances, which they're really not. And it varies state by state, that like the precise process, but if you start at the base of, notice in some states can be by mail. It could be by mail to the address where your future guardian is also living. And even if you get the mail, it's a legalese document. You check this box, which means that this other thing has happened, and then that box is checked. People don't meaningfully understand what is going to happen, and often the people seeking the guardianship don't either. Take even one step before notice, that people start this process thinking that it's just what they have to do because that's what a school told them, or that's what a family member told them, that's what they'd heard. And then hearings themselves are often, they can be seconds long, these hearings. You might not be at the hearing. Your voice might not be heard. There might be no opportunity for you to say, hey, I don't want this, or I don't like this, or I don't understand what's happening here.
And let me ask both Ms. Brennan Crone and Ms. Whitlatch. I talked about the facts in Britney Spears' case, that she was denied a lawyer initially based on a medical report that she wasn't allowed to see and the lawyer wasn't allowed to see. How common or uncommon is something like that?
Do you want to go?
No, I would say that I have seen that kind of circumstance before, where it's difficult for the person is not given access to medical evidence that's being used against them. I can't say how common it is, but I have experienced that within my career. And I think what it takes is really, really zealous advocacy. But in circumstances like you're describing, that kind of zealous advocacy of express wishes to be able to challenge the evidence that's being used against you did not appear to be present. And I think it really highlights the fact that there's a deep importance in having access to attorneys of your choice and attorneys that are advocating for your express wishes, because that's another big issue that I see, where attorneys are advocating perhaps for what they believe is in the person's best interest, or these systems can be very insular. And, there can very insular systems that aren't really based upon a kind of civil rights focus. And so those can also be challenges when it comes to guardianship proceedings.
Now, Dr. Kripke, you spoke some about alternatives to conservatorship. Can you describe the efficacy of some of the alternative mechanisms to deal with someone with diminished capacity?
Yes, so we work as a team to deliver healthcare. Healthcare for people with developmental disabilities is interdisciplinary, team-based care, and it includes not just the healthcare providers, but the people who provide direct support to the patients, whether that means personal assistants in their lives, day program staff, job coaches. Everyone who's in their life has a part in recognizing when someone is ill, alerting a doctor when there's a problem, and in supporting that person to make the right decision for them, and then in carrying out the plan. So we work together as a team to make healthcare happen. And when you have a conservator, it's only one person, and that one person may or may not be a part of the day-to-day life of the person we're talking about, and they may make decisions that the team as a whole doesn't feel that they can implement and doesn't feel bought into along with the patient. So we work together collaboratively and work towards consensus instead of putting decision making in a single person's hands.
Okay, Mr. Slayton, you were able to participate in the process in Texas to identify the need for state guardianship reform and oversee its implementation. Can you walk us through some of these state law reforms and how they help create greater due process protections?
Sure, Senator. I think one of the things that we started doing was having a conversation with people under guardianship advocates, and really begin identifying some. And I think, as has been noted here, one of the keys is, changing from maybe what's been described as a pro forma system to full guardianship is the last alternative that's explored. So one of the things Texas law now requires is that every individual that's filing for guardianship, every attorney involved, all the judges must consider all alternatives to guardianship, all supports and services that could be offered, and then the judge has to find by clear and convincing evidence that there are no other alternatives to a guardianship. So it's obviously a high burden of proof to get there. And then one of the things I was thinking about with Mr. Klaus's situation, one of the things we did in Texas was it is often that someone with a traumatic brain injury or someone that has a stroke oftentimes get placed under guardianships, but their conditions improve. And so one of the requirements under Texas law is that when the doctor is doing the evaluation for a guardianship, they have to state in their report what the likelihood of improvement is and what time frame that's expected. And the judge is required to reevaluate the need for the continuing guardianship in that time frame and continuously doing stuff. So it puts in place these due process protections to where this is continuously occurring. And the last thing I would say, there's a whole series of reforms that we could go through here and spend some time, and I've submitted that with my written testimony. But another big one is really this idea of making sure that family members and friends are adequately informed about what their responsibility is and isn't. What we have found, as is noted in someone's previous testimony, that the majority of the issues come up when it's a family member or friend guardian who let's just give them the benefit of the doubt. Maybe they don't know what their responsibilities are, what the limits are, and what other options they have, for instance, support decision-making or other types of alternatives. So making sure they're aware of those situations before they're in a guardianship is really important. And I guess I would just say that I said last thing, but one more last thing is this idea of the Bill of Rights. It was a really important development in Texas to really put in writing, these are a person under guardianship's rights, and that must be provided to them. And every year, in conjunction with the report given to the court, the person under guardianship has to be provided with their Bill of Rights again, and that so that they understand they have the right to go petition the court to have the guardianship terminated. And I think those are all things that have been really important, and I think have made a difference in our state.
So that's helpful. Let me, if I could, Mr. Slayton, ask you a hypothetical.
Sure.
Which is Britney Spears' conservatorship is under California law, but given the reforms in Texas, had a similar fact pattern arisen with those reforms, how do you think the case might have proceeded differently?
I think first of all, let's just pretend that the reforms were in place before the guardianship was established. I think there would have been a pretty significant mountain to climb about whether or not there weren't other alternatives that would have been more appropriate, or maybe there could have been limitations in the guardianship. Could there have been supports and services put in place that would have satisfied the concerns of the court or the medical professionals looking at her situation? So I think one thing is right off the bat, the question would be whether or not the guardianship would have ever been established in the first place. I think the second thing is that there would have been, under these reforms, a more natural review of the need to continue the guardianship. I think there's been difficulty in getting that looked at, and in Texas, I think under these reforms, it would have been a more natural approach, and the judge would have to again find by clear and convincing evidence that the need for the guardianship continues, and that there are no less restrictive alternatives that would be more appropriate.
Okay, that is very helpful. The time is expiring on the vote on the floor, and actually Chairman Blumenthal is back, so I'm going to run and vote and hand the gavel back to the chairman, but I want to thank each of the witnesses for your testimony, particularly you, Mr. Klaus. Your story is powerful, and to your wife, thank you for being here as well.
Thank you, Senator Cruz. You're going to miss my counting down by sevens, Senator.
Admit it, you practiced.
I didn't practice, and I'm not going to do it. Again, thank you for your patience. I'd like to continue kind of the topic that I was beginning to explore with Ms. Brennan-Crone. And let me ask all of you on the issue of financial exploitation, which I think affects not only people with disabilities, but older people. Maybe I can just ask all of you, and Mr. Klaus, you're free to talk about this issue as well from your personal experience. Financial exploitation, how common is it? Maybe you can give us some examples.
I'm happy to take a start here. In Texas, we've looked at 55,000 guardianship cases. And I want to pause here and say the vast majority are by people who are trying to protect their loved ones, and they're doing the right thing. So as was pointed out, the ones we hear about are the bad actors, but there are a lot where the situation is good. But I have, we in Texas have found over and over again financial exploitation occurring. I've got a whole list of examples. Just looking here at, basically we had a guardian whose license was revoked by the state oversight board after a financial audit revealed that the guardian had removed $10,000 and over $10,000 in cash withdrawals without any cooperation. They just were going to the ATM and withdrawing money from the person's estate. We have a situation where a Whirlpool tub was installed in the guardian's home using the proceeds from the estate of the individual under guardianship. Over and over again, examples. It's kind of like uncovering a terrible onion, and every time you peel back the layers of that, it gets worse and worse. I would say it is more frequent than we would like to, that we would be comfortable with. Even if it's not extensive, certainly there's plenty of it going on and something that should be a concern for all of us.
Yeah, I absolutely agree that it happens. We don't have the data because we don't have any data, but the system is set up so that it's very easy to exploit someone financially. But I also want to say that there's outright financial abuse and fraud, and that happens undoubtedly and is very significant. But there are also this very large number of cases, and perhaps Mr. Klaus's case, part of it was sort of in this area, where maybe it's not outright fraud, but you have someone who's controlling the person's money for no particular reason, or certainly not for any reason that's based on, this is what I think we need to do to help you learn how to manage your own money. And I think that shouldn't be underestimated, that even in cases where, you're not putting a hot tub in your house at your ward's expense, you can still be causing a lot of financial harm by not supporting the person's development and by mistreating them. The psychological harm of being told you have to ask to fill up your car with gas, even if all that money is still sitting there and waiting for you, is a really big harm. And I think that's extremely widespread.
Thank you, Ms. Krippe. Dr. Krippe.
I think that financial exploitation is unfortunately very common. In conservatorship, you have to go to a judge to make a change. In supported decision making, however, if you don't like how somebody is managing your money or managing you with money, you can change the authorized representative on your CalAble account. You can change your representative payee who is helping you with your bank account for your SSI checks. You can change trustees who are not acting. And so trustees, conservators often perform well and then develop disabilities themselves as they age and may not be able to provide the same level of support. And in supported decision making, you can switch them out. In a conservatorship, it's a much more complicated process.
Other comments? Ms. Whitlock?
Yeah, and I just also want to say, I think when we talk about the legal tools, be it powers of attorney, be it guardianship, be it conservatorship, be it representative payeship, all of those tools can be misused by bad actors. And it really is about how do you create the support networks necessary to kind of create the checks and balances. And with guardianship and conservatorship, that's the guardian and conservator is wielding a great power that doesn't have the kind of oversight frequently that's required to. And it's why you can see some really egregious cases of financial abuse.
Mr. Klaus, I'd like to ask you to tell us how your conservatorship ended, how you managed to end it.
Well, I was able to get in contact with the IDR, and they set me up with Justin Schrock, and he immediately knew my case was special and saw that there was no need for a guardianship just by talking to me and hearing about my experiences and my jobs I've held. My guardians, they often made me jump through hoops to get things done. They wanted me to go see a psychologist and have a neuropsych evaluation done. And after a few weeks of going back and forth, we finally gave in, went to the one that they wanted me to go to. And without a doubt, the psychologist said that there's no need for guardianship in her report. And shortly after that, we were able to get the guardianship terminated.
Was there opposition to terminating it? Did they try to keep it in place?
They opposed it from the very beginning when we gave them notice that we were challenging the guardianship, and they drug their feet the whole way.
How long did it take to terminate it?
Roughly a year and a half after we had served them.
I'd invite others to comment on the process of terminating guardianships, how often it occurs that someone who's subject to a guardianship wishes to terminate it.
It is very difficult to terminate a guardianship and conservatorship. It is very resource intensive. Speaking as someone who has represented people in restoration of rights proceedings as an attorney for a nonprofit, it is very resource intensive to be able to provide that kind of service. People can face all sorts of barriers. Some people don't know what attorney to go to. Like to go to Indiana Disability Rights. Some can't access attorney in that way. Some attorneys refuse to represent people who are under guardianship because they have concerns that they're not ethically able to do that for someone who's been adjudicated and incapacitated because of certain kinds of ethics rules. I think a really big issue is, having to face paying for actually the opposing parties, not only your own legal fees, but the opposing party's legal fees. There's a system that's set up where it's the person who's under guardianship in some states that have to pay those kinds of fees. And I think getting the kinds of evaluations that Nick is talking about can be very difficult too. There's a tendency when we talk about, quote, incapacitated, unquote, for, traditional kind of psychological evaluations to really link that to diagnoses and IQs, and some diagnoses are static diagnoses. They're not going, you're not going to not have an intellectual disability, for example. Nick has a history of a traumatic brain injury. Those are things that exist. Some people have certain kinds of IQ scores, and these evaluations don't really look at the options for less restrictive alternatives to guardianship or really the functional abilities of someone to either direct their own life or direct someone else to manage their own lives. And so it can be, I've been involved, for example, Jenny Hatch, you heard today. That was when Quality Trust got involved. We were preparing for months. We had a host of experts that we had to retain to show that a person with Down syndrome didn't need to be under permanent plenary guardianship. We had 6 days of trial. Very kind of resource intensive. It can be very difficult to terminate a guardianship, and it's why we really need to rethink how people get under guardianship in the first place. It's much easier to establish a guardianship than it is to terminate one.
Other comments?
I'll just echo what Morgan said. It's the strength of the current to get into guardianship is just as strong against you when you're trying to get out, and that people have no idea what they're getting into when they start it. And then the barriers, like even very practical barriers, if you're in a guardianship, like, these new revelations about Britney Spears' surveillance. If you're in a guardianship where you can't have a phone, that's very common. I mean, the complex surveillance of Britney Spears is probably less common, must have been wildly expensive, but very common to not be able to have a phone, not be able to have access to the internet, not have access to your money. So you're going to hitchhike into town and hope you find your way to a lawyer who can do this. Like just the very practical barriers to having any idea of how to try to challenge a guardianship are insurmountable. And then there's a real reluctance by courts to dissolve guardianships, often in cases where the fact of a disability remains, which is true for most disabilities, that they are lifelong realities, and you will have a disability for your whole life in many cases. But that doesn't mean that you won't change, and you won't learn, and you won't develop, and you won't have preferences, and you won't be able to use supports to help you. But I think judges very often think of it as, oh, well, this person, they still have an intellectual disability, so what could be different here? And that's a really mistaken view.
Mr. Slate?
So one thing I would say is this just points to the need for sort of a systemic procedural way for this to occur. As I mentioned when you were out of the room taking the vote a minute ago, that one of the things that we did in Texas was, as part of the, if someone is, let's say they have a traumatic brain injury or a stroke and they are placed under guardianship, that there's a process that those automatically get reviewed to see if there is a continuing need where there is clear and convincing evidence that no other alternative is appropriate other than guardianship. And then in the annual reports, the well-being reports that are required to be filed every year, that there's a discussion and a review about whether or not there is a need to continue that guardianship. It has to be part of the process. If it's just sort of, well, maybe at some point this will get brought up by someone who, as was pointed out, hitchhikes to and successfully finds a lawyer who's willing to take on their case, that's probably less likely to be effective and really providing a robust way to review these. I think it points to the need for states to really look at ways to make that happen.
In 20 years of practice, I've never had anyone who was able to get out of a conservatorship, but I have had conservators die or develop their own disabilities, and I don't know what happens legally. I think the conservatorships just sort of fade away and we carry on as if it hadn't existed. I've also had conservators who no longer wanted to serve in that role because they developed other caregiver responsibilities for other family members and developed their own disabilities and were denied by the court to get out of serving in that role, which is a very intense and difficult role if you're making all the decisions for another human being, doing all their finances, doing all their health care, especially for somebody with a complex disability, is not a small job. And I think people don't realize what they're getting into, a lifelong commitment to doing that.
For the kind of evaluation that was done in Mr. Klaus's case by a psychologist, I assume, that psychologist is hired by the conservator or the court. I don't know what happened in your case, but I would expect that a psychologist who's hired by one side or the other, whether it's the court or the conservator, would have probably some professional interest in upholding the status quo. I don't know whether any of you have had enough experience. I would guess that Mr. Klaus's experience may be somewhat unusual, where the psychologist concluded you were able to do without it.
Actually, we had to financially split the psychologist. I was willing to pay up front for it so I could obtain my freedom, because I had no doubt that the psychologist would find me competent, but my parents were reluctant to.
So you had to pay for the services of the psychologist yourself?
Yes, sir.
I would say, it really does vary upon state systems as to how those kind of evaluations occur. I've worked in different jurisdictions. In some courts, they have like a panel of, examiners or evaluators that are used to evaluate people who raise when questions of capacity or regaining of capacity are raised. I've also worked in jurisdictions where it's about agreement between the parties as to who would be served as the evaluator. And frequently in the cases I'm involved in where I'm working on restoration, we as the nonprofit go out and we want to pick who our evaluator is. We want to make sure that they have the right values and think about disability in the way that we think about disability, that look beyond IQ scores or diagnosis and really look to the kind of core of a person and the alternatives to guardianship. But you can bet, that latter kind of approach can be a very kind of costly approach, but an effective approach to trying to seek restoration.
Let me ask you, Ms. Brennan-Crone, when an individual in conservatorship becomes aware of their right to seek full restoration, and the rest of you as well, or they push for less restrictive alternatives, what is the most likely outcome? The reason I raise it is that the standard, I think Mr. Slayton may have mentioned it, is clear and convincing evidence to overturn a conservatorship, or in other words, the burden of proof is a pretty high threshold. Clear and convincing evidence is not proof beyond a reasonable doubt, but it's a lot more difficult than a preponderance of the evidence. So maybe you could talk about, in effect, how the legal deck is stacked against someone seeking restoration or a less restrictive alternative.
Sure, yeah. And like I said, the people who get themselves into court are a very small minority of people who probably want to get out or who shouldn't be there. But by the time you get to court, it varies by state. And some states don't have clear standards at all about what the burden is and how the burden works for restoration proceedings. In some states, the burden is on the person under guardianship to demonstrate that they no longer need a guardianship, which is incredibly difficult the guardianship itself may be really self-fulfilling. It may be that you still don't know how to balance your checkbook because nobody's told you how to balance your checkbook because you're not allowed to balance your checkbook. And that, the idea of the sort of Kafkaesque thing, people say a lot of stuff is Kafkaesque, but it really is. But also, how do you prove what you can do if you haven't had the opportunity to do it? So I think it's really important that the burdens exist, similar to how they do in Texas, of that the person who wants to keep you stripped of your rights is the person who has the burden to show that they should be able to do that. Like all of there's so many defaults in the system that like default to guardianship and default to guardianship lasting forever. And we really need to change some of those points so that at the hearing, if your guardian can't prove that there's nothing else, they can't prove that they've tried supported decision-making, they can't prove that this is the only option is stripping you of all of your civil liberties, then that's the end of the guardianship. That's really how it should be, and it's rare for it to exist that way in states.
It strikes me in trying to end a guardianship, even if you could get a ride into town, and even if you could find a lawyer, having been in private practice as well as a prosecutor, my first instinct, somebody walks in the door and says they already have a lawyer, would be to call the other lawyer, just as a matter of professional courtesy, as it's called. I've been chewed out by some lawyers for not calling them. As a legislator, when I tried to do things on behalf of someone who had a lawyer, when that person actually denied he had or she had a lawyer. And we all have these professional instincts about contacting the lawyer. And so I think that's an additional hurdle. There's a financial hurdle, there's the kind of logistical hurdle, and then there's the professional hurdle of lawyers generally being unwilling to take cases from other lawyers when they're represented. And in a lot of places, that lawyer is likely to know the lawyer who represents the guardian. So unless you find someone like the people on this panel who are independent and whose job it is to fight for people who want restoration or a less restrictive alternative, there are just so many hurdles in the path of termination.
And I totally agree. And just to add one thing is that sometimes in that situation, you don't have a lawyer and you've never had a lawyer. That most states, there's a right to counsel in some way in appointing a guardianship, but not in all states. And so you might actually not have somebody else who's even technically your lawyer. But yes, having somebody who understands this, there's such a lack of disability competence in a lot of professions, not just lawyers, but we're among them, of people who just don't know where to begin if they're talking to someone, who has a disability, and there's something about incompetence and they worry about ethics. And I think it just, lawyers don't really know how to proceed with that, and so are likely to sort of not know where to go and not take those cases, or know how to take those cases thoughtfully and with disability competence.
Let me ask all of you, what would be your preferred federal reform? In other words, as has been observed a number of times, guardianships and conservatorships are creatures of state law, whatever their defects and advantages. And I take your point, Mr. Slayton, that maybe by and large the majority are well done. That may be. We have no real numbers or overall evaluations to show, but based on your experience, what would be your preferred federal reforms to protect the individuals who are under guardianships or conservatorships? And you can go in whatever order you would like.
Well, Mr. Slayton talked a little bit about like court improvement program to try to kind of incentivize creating certain kinds of due process protections and bolstering them within states. I do see some value in that, given there is such unevenness that's across the United States on these kinds of issues. But again, I really do say, as I did in my testimony, that we need to also have more investment in trying not to get to conservatorship and guardianship in the first place, to really look closely at the pipelines to guardianship that we've discussed, be it healthcare, be it schools, and think about the kinds of federal investments that could be made to dismantle those kinds of pipelines. So looking at, pushing for the funds that are going to school systems, which are the number one referral for guardianship based upon some recent reports. That was really highlighted in the National Council on Disability report, and saying, you need to be looking at less restrictive options. Schools, when students reach the age of majority and can be in special education until they turn 22, you should be really informing families of all the options, including supported decision making. You should be looking at robust transition planning processes for people with intellectual and developmental disabilities and students with disabilities. When you look at trying to, advance supported decision-making pilots and other projects that would reach more diverse populations, there have been a number of pilots in the intellectual and developmental disability field. We should look at them for older adults who I've also represented in getting guardianship terminated in favor of supported decision-making. How can we make sure that those kinds of options and less restrictive options reach that population as well? How can we look to try to promote robust funding of the very civil rights-minded lawyers that we were talking about when we talked about, disability sensitivity in representation? So I think there are a lot of investments that need to happen in that, and kind of coordination to be trying to promote less restrictive options to guardianship, because it is an overutilized tool.
Mr. Slayton.
I think one of the things that, recognizing this is an issue that states and state courts oftentimes do, one of the things the Congress and the federal government could do to assist is really trying to help incentivize states to make changes. And one of the ways that obviously can do that is through the court improvement program. Senator Blumenthal, you were a co-sponsor in the 115th Congress of Senate Bill 178, which was the Elder Abuse Prevention and Prosecution Act. And in that bill, there was an authorization for demonstration grants to the states that would basically begin to prove out models of reform that would begin to make changes and some systematic changes, including data collection, evaluation, best practices. Unfortunately, that program has never been funded. So we don't have the data we need. We don't have the demonstration projects that can really show. Texas did it kind of on its own, but many other states, maybe the state legislatures haven't put the funding in there. And so I think really, if the federal government could really begin to think about ways to incentivize states through funding to make these reforms, obviously you all can place requirements on that assist with, looking at least restrictive alternatives and things like that. But I think that's really a way to begin to change this conversation, begin to incentivize states to really take a hard look at that. And without the funding, I worry about whether or not that's possible.
I agree with what's been said. I think, providing supports for states to expand alternatives, to collect data, all of that is really important. I think, at a very high level, what Congress can and should be focusing on is what you can do to dramatically reduce the number of people who've lost their civil rights and civil liberties permanently through this system. So I from my position, that has to be the sort of guiding principle, is that people having been stripped of their rights is a bad thing. And how can we make that happen less? And so I think, there are clear federal constitutional rights at issue here. These are squarely procedural due process issues. And so there's room for Congress to act on that and to enforce, rights to notice, to opportunity to be heard, a right to counsel as a combination of, procedural due process rights and taking into account the reality that the person has disabilities. It's sort of, can be justified as a reasonable accommodation using sort of ADA speak, Americans with Disabilities Act speak, to say, if you have someone who's, alleged to be incompetent, unable to direct their own life, and you're taking that seriously enough that there's a court hearing about it, but then you're not taking it seriously enough to make sure this person has an advocate to help them navigate this process, it's such a disconnect. So there's a lot of ways to think about and use federal constitutional powers and hooks to make the due process side of this much stronger and to build in alternatives to that. Like, I don't think it's not really either or, like, is the notice good or are you doing supported decision making? I think it has to be all of a piece to, make it so that more people essentially get kicked out of the guardianship system or never go near it, and they find something else there. Because just saying you're on your own, there's no guardianship, but there's no support either, is not realistic either. And so I think there's a lot of creative ways for Congress to engage on this and to break some of the sort of business as usual, which I think can be a real problem in these systems, that people sort of are used to doing things the way they've always done them, and they have incentives to do that, and they have, people have their psychological biases to keep doing things the way they've always done them, and there's some room to really shake that up, and it really needs to be done.
Ms. Kripke, Dr. Kripke.
Thank you. Without communication, there is no self-direction, and when people can't direct their lives, that's when they're most vulnerable to conservatorship or guardianship. We have some really good laws, federal laws, and some of them may need to be clarified and enforced. Communication access is a right under the Americans with Disabilities Act, the people's ability to choose how they communicate and to have their communication accommodated, whether they use pointing on a letterboard or an alternative communication device or other ways that people communicate without using speech, needs to be recognized as valid. And we have the legislation for that, but not everybody respects that legislation, so we could enforce it better and we could clarify it better. And for health professionals, we can reassure health professionals that working with supporters doesn't violate HIPAA and that they can rely on decisions that are made with support.
It strikes me in what you were describing, Ms. Brennan-Crone, as a kind of federal right of action, including notice and right to be heard and so forth, and periodic review. So maybe that's one of the areas we should explore. And then the absence of data and information, that's something certainly the federal government can do. We're supposed to be doing it on crime. There are a lot of holes in that system, lack of reporting in many instances, so it would have to be enforceable, and then maybe some standards for guardianship. But I agree with you, Mr. Slayton, that the best way to incentivize, if that's the route to take, would be to provide support for state court systems. In Connecticut, it's a probate court. It's a separate court. I don't know about other states. And they are almost an independent branch. They've improved greatly over the past few years, and there has been reform in this system in Connecticut, but there is still a need around the country, I think, for additional data collection, additional reforms, and incentives for those state court systems to do more. I was struck by a recent series of articles in BuzzFeed News that highlighted some especially egregious examples of repeat players in the guardianship industry who frequently take hundreds of clients, make millions of dollars, and very often neglect basic responsibilities and duties. In particular, the stories identify a Rebecca Fierley who, quote, made millions while controlling the lives and finances of more than 500 people before she was charged last year with abuse and neglect of an older adult ward who died after she had him placed under DNR and allegedly told doctors to cap his feeding tube. When police raided her office, they found urns containing the cremated remains of 9 former wards on display, end quote. Maybe I'll ask you, in your experience, are there instances of these kinds of lawyers, we're talking here about lawyers who fail in their responsibilities in that really criminal way or bordering on criminal, where the legal profession itself or the courts or someone should be exercising greater scrutiny?
I'll jump in here and say in Texas, one of the things that Texas did was to begin the regulation of private professional guardians. So you've got family members and friends, and I talked a little bit in my testimony about how we started doing some things recently, but the first reform that was made back in the early 2000s or mid-2000s was to begin to require licensing, testing, and regulation of private professional guardians, putting limits on the number they can have, requiring certain continuing education, and then having a complaint process where someone could complain and there'd be an investigation. Not every state does that, and I think it's really important to make sure that individuals who are being appointed by the court and being trusted by the court have some sort of oversight professionally where, and we've had situations in the state where those private professional guardians have abused that responsibility and had their license revoked, and even recently federal or state criminal charges against that person for abuse of several of their persons under guardianship.
Yeah, I think there are these high-profile stories and not high-profile stories that I've heard of people who report really egregious criminal or bordering on criminal conduct by guardians and report that there isn't a mechanism to complain about that gets anywhere. And I think, one part of that is that we should have better mechanisms where people can complain, better oversight, like Mr. Slayton is talking about. But I also think it goes to the really fundamental issue, which is if you give someone that much power, people are going to use it. And having, power corrupts, absolute power corrupts, absolutely. Like, we're building out a system in guardianship where people are invited to do things like that, and many people won't, most people won't, but it's a sort of built-in risk if you're going to give one person such extraordinary power and unchecked on a day-to-day basis. Even if there's some reporting, you can go along unchecked for a long time over a person with disabilities.
I would just note that in 2018, the Senate Special Subcommittee on Aging, I'm a member of that subcommittee or committee actually as well, released a report recognizing the impact of the guardianship system on the health and well-being of seniors, as well as people with disabilities. And they found many of the themes of that report are very similar to this one, as I'm sure you know. So I would just highlight again, we've been talking about people with disabilities, people with injuries, but I would guess that these issues are very common with people who are elderly, people who may have onset dementia, and I would guess courts would find it very difficult to make distinctions among these people, which again calls for the need for standards, maybe some right of action, federal right of action.
Could I just add one thing to that? Simply that I totally agree. And when I talk about disability, I'm including people who age into disabilities, who don't necessarily think of themselves as disabled, but dementia or any sort of age-related changes in your ability are, in my mind, in the disability space. So I totally agree that but it's a different experience to age into disability than to have a traumatic brain injury than to be born with a disability. So I think it's important to be mindful of that full range of experiences and disabilities.
I would just also add that I do think that there's a lot of misunderstandings around, just as there's misunderstandings about what an IQ test does or means or doesn't mean about someone's incapacity, so too there's a lot of misunderstandings what a diagnosis of dementia is. And I recently co-authored an article that looked at supported decision-making specifically within the context of older adults, including older adults that were had dementia. And there are different factors to consider within the context of older adults. You know, their support networks look different. As you're aging, you know, your natural support networks may fall apart. You may not have, you know, you might be more isolated. When you're talking about a question of, we talk about in the disability world, a question of kind of building capacity. What do you do when you're talking about diminishing capacity? How do you plan for that? And I do think that there still remain options other than guardianship within those contexts.
Great. I think we've taken a lot of your time. I really appreciate your generosity and giving us that time. And I want to thank again Mr. Klaus for sharing your personal story. Always difficult to come in this kind of setting and talk about a personal experience like yours. So we're very much indebted to you and your family for being here today. I commented at the beginning based on the Britney Spears case, but I think it applies to so many that we need some reforms. The federal government can play a part, at the very least, in incentivizing reforms, in enabling better data collection, so we are dealing with a little bit more of a known challenge. But we know that there is a need to strengthen state systems, provide alternatives. I think that's one clear theme here, that there are options and alternatives to the very straitjacketed approach that conservatorships can take. We need to improve oversight so that there is some independent scrutiny and maybe some best practices and data collection among states and with the federal agencies. And for me, as a former prosecutor, enforcement. I think a number of you have noted that there are laws already. I think Dr. Kripke, you mentioned it most recently, laws that may be unenforced right now because we don't devote the resources or we don't give it enough priority. So I would like to thank all of you for devoting your lives to it. This is not kind of a sidelight for you. This is your life's work. And it's very, very profoundly important work. And I hope that we can achieve some changes in law that are worthy, Mr. Klaus, of your courage and experience and the courage and experience that you have all devoted to this very, very important area of our law and our life's experience, because the chances are very good that one or more of us in this room today may be placed in some kind of conservatorship or guardianship, and that a less restricted, supported decision-making option might be more appropriate and more valuable to us. So again, my thanks to you. We will be in touch with each of you. We're going to keep open the record in case any of my colleagues have written questions for you. We'll keep open the record for a week in this hearing, but I can assure you that we will be back to each of you in the course of our considering potential federal reforms. With that, I'm going to close the hearing. Thank you very much.